2030. Now, looking at the technology that we're being asked to concur to, the 14,791 megawatts includes, as I said, PV and wind, which is obviously going to be needing some form of storage, as the minister has proposed, to smoothen the effects of the variability of the renewables. Hence, if you look at the technology, there is a balance with regards to what the minister is determining. And then looking at the procurer of this electricity, the DMRE will be procuring this capacity under the REAP program, as I mentioned earlier. And then the buyer of the electricity will be Eskom. We know that currently Eskom is a single buyer of IPP capacity, and that will remain as such. And then the timelines for this capacity, the minister has determined that this capacity will be required as soon as reasonably possible, in line with the Table 5 of the IRP 2019. And we have asked stakeholders just to comment on the timelines, on the technology, on the buyer that is determined, and also on the procurer that is determined by the minister. And then just to draw your attention to the Section 6 of the submission, Table 1 indicates the timelines that we are expected, to work these three determinations under, which is a period of about a month. Normally, the regulator does concurrences in a period of about 3 months. However, as in support of the initiative of government, we are also being called upon to act and to be able to deliver in that 31 days. So as I conclude on this paper, based on the above, we are requesting the Electricity Subcommittee to approve this consultation paper as per Section 14 of the submission as follows. A, to note the request to concur with the proposed determination in terms of Section 34 of the Electricity Regulations Act. B, to approve the publication of the consultation paper, which is attached to the submission. And then C, to recommend to the ER to note the consultation paper. And lastly, to note the indicative project timelines, which are stipulated in Table 1. With that, Chair, I'd like to thank you and would welcome any questions or inputs from members. And maybe I would just like to comment that we have already received some feedback from members, and we have already incorporated the comments in the consultation paper that the comments were directed to. So with that, we just want to say thank you and open up for questions. Thank you.
Thank you, Mr. Mkiza Jr. And I'd like to also thank Mr. Mkiza Sr. for the comments that he's already made to the consultation paper. That is much appreciated, Kawaza. So members, you've got the document before us. Any comments, questions of clarity? Madam Assetti.
Thank you, Chairperson, for the opportunity. I've got two issues, Chairperson, that I think are very important as we are taking decisions on these important matters that are intended to contribute to the security of supply. One issue that I would like to raise, and I would like to find out how prepared are we as NERSA, is the issue of storage. And I think it's the second time that I raised this issue with regards to the regulatory framework for storage. If I can just be clarified as to what is NERSA doing in trying to empower us with a regulatory tool or mechanism that we can use to be in a position to approve even applications or even a request for concurrence. Concurrences that comprise of storage facilities that need to be procured. I believe that even when we are confronted with these kind of requests, it is very important that we do touch on our jurisdiction when it comes to storage, so that at least our position is very clear that even when perhaps our jurisdiction is very much limited or is very silent in terms of storage, the licensing or the license for the operation of storage facilities, we don't have that in the Act. But if there is any initiative, at least some proactiveness from our side in trying to support government initiatives and in line with what the country needs currently, at least it is still important that the energy regulator is very clear as to what is it that we're doing. So can I at least be clarified on this issue as to how do we at least show in our decisions that despite the fact that issues of jurisdiction when it comes to storage, the licensing of storage facilities is not so, is the Act is silent. What is it that we have taken to try and facilitate investments around this area? So that's one thing that I would like to understand, at least from our side, because I do not recall the energy regulator making taking a decision to approve some regulatory tool, even if it's at least guidelines around that to say, or some rules to say how we're going to deal with that, and also maybe categorize some storage sort of facilities that are meant to support maybe some transmission, but also facilities that are primarily for storage and deal with jurisdictional aspects of it. The second thing that I would like to raise, again, is it relates to the need for us again to consider, for purposes of grid stability and also just ensuring that there will be available capacity at the grid level when we approve this type of requests or concur. There is no mention of perhaps any possible challenges of network congestion at a transmission level, at least to pave way for the connection of these projects that we are required to concur to and look at the capacity. The capacity is quite substantial and we appreciate that, but it is also very important for us at the regulator level to understand how this capacity is going to be accommodated to the grid. And I think that it is important that we touch on the issue of network availability and the possible network congestion, and also just take into consideration perhaps some investments that may actually be required to ensure that network will actually be available. And remember, some of those investments will also affect Eskom to the extent that Eskom will need to make sure that it invests in the grid upgrades or expansion of the grid, whatever that is actually required. And we must remember that it is also a cost. I think it is something that we should also take into consideration. Those are the two critical things, at least from my side, when it comes to the strategic issues that the energy regulator needs to apply itself to when it comes to this type of request. Thank you, Chairperson.
Thank you, Madam Massetti. Advocate Sithole.
Thank you, Chairperson, and thank you to Mr. Kiza and Shuzi for the presentation. Mine is just one question, which is on the procedure, which is in reducing these timelines, because I've noted that you have reduced them from 90 to 31 days in considering the application. Can the team really give us comfort that the reduced processes will not lead us into any legal challenges, whereby we get taken to court on the basis that we didn't follow the full procedure? Just for the comfort of the committee and myself, Chairperson, if they can just confirm that the reduced timelines will not compromise us in terms of our legal processes. Thank you, Chair.
Thank you, Advocate. Mr. Mkhize.
Yeah, thanks, Chairperson. As you have said that I've made some comments, and thanks for the attitude. But I would not have loved to really talk to in this meeting if Kabazela had just spoken to the questions raised, so that for the benefit of other members and also those who are on the platform. I would not go to other matters that were raised, but specifically talk to the issue of the grid. I mean, but three issues. One being the issue of the grid stability and all the highlighted by Madam Masete in the submission is not put forth as such, but I appreciate the fact that it is there in the consultation paper itself. Maybe you can just even maybe in the writing expand on that, just to say, noting that there will be additional electrons put through additional power. So it's just to be able to talk to that one. Two is the issue of the timelines, because effectively it is 10 working days. And my question was, why not have 21 days, which will make it 15 working days, probably, noting that we've got 3 of these, because we don't want to rush. Actually, we are shooting ourselves in the foot when one considers the fact that then there are comebacks that this process was unduly rushed at the front end. And I'm of the view that whilst work is taking place at the front end, there could maybe be some work, that preparatory work that still goes on concurrent to this process. When one takes a view that this is already spelled out in the RP 2019, and therefore it could be a question of I would say some logistics and how things are sequenced, rather than actually not at all doing it as such, without necessarily preempting the outcome. So I think that that kind of positive attitude can allow some work to proceed concurrently, and therefore save time. And also in the indication of time, you are not providing whether this process is actually sitting on the critical path, because when one looks at project management, one considers whether an activity or a deliverable is actually sitting on the critical path, and I don't think that that 1 week more would actually break the camel's back. I would just like to get that understanding, which also is in line with what the CEO has alluded to. And then the other thing is that on the question of whether ESCOM should participate, this is the last one, which is under your paragraph 8, is that you expand it to not just to refer to ESCOM, because entities like Central Energy Fund, which is SEF, could also participate. or any other state-owned company, whether coming from the province or whatever, just to open that question widely, and also not to talk as if Eskom or will take the whole allocation or determined capacity of 14,971. But megawatt can take a portion, just like this is not going to be taken up by one IPP, but several IPPs would participate, taking chunks of that. And then lastly, from my side, I would just like to get clarity in terms of storage, whether we require that even the companies that or entities that would be supplying generating solar or solar PV or wind energy would also have storage just to in consideration of the amount that is to be generated to deal with the challenges of the dark curve, or we only are looking at pump storage being separate from these entities that will be providing solar, photovoltaic or wind energy. Just that clarity to be provided. Thank you.
Thank you, Mr. Mkhize. Madam Pungose, over to you, ma'am.
Thank you, Chairperson, and good morning, everyone. Chairperson, I just have two questions from the team and thank you to the team for the presentation. It was quite detailed. I just wanted to find out in paragraph 8, where it makes provision that the determination makes provision that the electricity must be purchased from the IPPs. And also we are inviting stakeholders, the team is inviting stakeholders, to comment on whether it is preferred that Eskom be the generator or the IPPs be the ones from whom they source electricity from. Obviously, on a personal level, I would have thought the most preferred method would have been sourcing from the cost-effective solution, use the one that's most cost-effective. But I'd just like to get a sense from the team, do they have any standing position that they would prefer, obviously informed by something, a study or something on what would work better? Do they have any standing position on what would be preferred? Personally, as I said, I think the most cost-effective would make sense. And then also I support the point that was made by Mr. Mkhize that it must be opened wider and not only restricted to the IPPs and Eskom only. It must be open to only all the others like the CEFs and the others. So I do support that. And then the other question I wanted to find out, seeing that we've got 3 of these, the expedited process, understand the reason, the logic behind why we ideally would like to go the expedited process. However, the timelines we've allocated, from publishing the notice and inviting comments, is that sufficient considering that it's for 3 different notices? And also the period we've allocated for analysis of stakeholder comments, which is like 3 days. Do we have sufficient capacity internally as NERSA to be able to consider all this comprehensively, in greater detail go through them with a fine tooth comb within the time period that we've set out? Is there any leeway of slightly, extending those timelines, those 2 timelines, the publishing timeline for comments, as well as the allowance for analysis? Those are my 2 comments, Chairperson. Thank you.
Thank you, Madam Pungose. Mr. Shozi, with your permission, I think it would be. It seems to me that the key issue would be a legal side, which I was hoping that we would have invited Advocate Mrati anyway to comment on, in terms of the stakeholder consultation, whether what we are proposing is even legal, and that we're not going to have comebacks as clearly asked by Advocate and other members. So if you don't mind, can we start with Mr. Mrati, just giving us an indication in terms of the process, whether the process as we proposed is legal or not, and then we can then go to the critical path question, I think, as the other critical question. Why are we even doing this? Are we on the critical path in terms of the procurement? Can we start with Mr. Murati, please? As we are responding. I'm just guiding Mr. Shozi. The platform is yours. I will add if there's anything that I may need to add later. Right.
Thank you, Chairperson. Good morning, members and colleagues. Chair, I think maybe a context to this issue that the reason where we are is because of the provisions of how Section 34 reads, and also the Earth Life judgment, which highlighted that our process, even though it's interlinked with the decision of the gazetting of the decision by the minister, the interlinkage does not absolve each party to carry out what the law expects, more so the promotion of Administrative Justice Act, which requires that the decisions that we will be taking, it's an administrative action. Therefore, dependent on its nature, we need to be complying with either Section 3 or Section 4. And the decision that the members are expected to be making, it affects the entire public. Therefore, Section 4 will be applicable. When one reads Section 4, it generates kind of two processes. You either have to go through the public participation process, which either is a notice and comment, public inquiry, or public hearing. Alternatively, you do not do anything of such. You deviate from it. But when you do that, which is not a preferred means, you must have such valid reasons that is reasonable and justifiable. Then you have regulations, the PAJA regulations, which sets out the details of each activity. But what you have, and which is fundamental, is that the process that has been chosen to be followed, because either of the three processes, it's legal. Either you do notice and comment, it exists on its own. You do public inquiry or public hearing. Either of them exists on its own. You would have satisfied the requirement, or you can do a combination of them, notice and comment and public hearing. You would have satisfied the requirements of PAJA. But what we sitting down with, and I hope colleagues, when they start talking in details about what we are dealing with, is some of the aspects that we're dealing with are not new, which one would have said the principles that are detailed in the Code of Good Administrative Conduct from PAJA. The one would said, if this was a totally new exercise, one would say our processes of shortening it actually compromises the satisfaction of the requirement of the law to afford stakeholders an opportunity. So this is a kind of an exercise that we have been doing over an extended period from B21 to date. So, Chairperson, the first answer to it is that notice and comment process, it's legal. Two, the number of the days that we can afford, the law gives the discretion to say you could go for a full 30 days, or if you have a valid reasons to go for a lesser of that period, and such decision for a lesser of the period, it must be based on the nature, purpose, and the likely effect of the administrative action concerned. The second part being the agency of taking the administrative action or the agency of the matter. So those two characters that the law has recognized that can enable an administrator, that can enable NERSA to minimize the period, satisfies the requirement of the law. And as I highlighted earlier, that some of the issues that we are faced with, they are not basically new to the industry. The industry has participated in the process over and over again. So the answer to that again, Chairperson, is that the period that we have chosen, considering the circumstances that we are exposed to, considering that the industry has been involved in this process, and also that the finality of this process is when the preferred bidder status is announced. Then the public in that instance can also still have the ability to challenge it. We would have satisfied the requirements of the law, and the decision cannot be exposed to any judicial review in terms of Section 10(3) of the National Energy Regulator Act. Thank you, Chairperson.
Thank you, Mr. Murati. I think Mr. Shozi may call on you again. Maybe I could. Can you answer the first question by Madam Maseti in terms of the framework for, in terms of our jurisdiction to regulate storage?
Thank you, Chairperson. I'll try, and if colleagues probably assist if I did not cover the question very well. Yeah, Chairperson, around the framework, if NERSA is ready, was prepared to regulate such technologies. What we have done so far in terms of the regulatory tool that we have developed is for the grid code, how these storages will be interconnected within the existing systems. Because in our view is that the storage is not different from your pump storage, like your Drakensberg and so on. They operate exactly the same. So we developed our code to ensure that they also comply with the requirement as the other pump storage are required to do so. In terms of the licensing rules and guidelines, I'm not sure. What I know is that we have received an application to license Eskom battery storage, and that process is underway. It will be considered by the energy regulator. In terms of what conditions or what guidelines were used, I'm not sure, but I know that the battery storage, it operates exactly like your pump storage. When it generates, it's a generator. When it absorbs, then it becomes a battery. But my colleagues will cover me on that one. The possible challenges around congestion on the transmission network. What we use we don't do a planning as the regulator as such, but how we influence the planning by the system operator or transmission company. In this case, it's Eskom. We have a network code, Section 7, which talks about how the transmission company needs to develop the network code, so that it doesn't prohibit the connection of generators like we are trying to do. Ms. Masset is right. This is a huge amount of energy that you want to inject. So what the planner will do, they will using where they source their information, they also look at the integrated resource plan. In this case, our determination is from the IRP. So they also use information when they are doing the planning, what technology is going to come online by when. So when they are doing a strengthening of the transmission or distribution, depending where the plant is going to be connected, it is the responsibility of the planner to consider such information so that when the plant comes online, it is able to be connected without any congestion. So that part is within the system operator, and how we influence it. We put regulatory tools in terms of network code Section 7, and currently we have we call it transmission network development plan, which is in place. Is updated annually. The current one was developed 2013, 2022. So as of
end of this year, we're going to have another 10-year plan, which will also be reviewed every year. The issue around the standing position, NERSA, at this stage, we've not developed any position. This is a project.
Mr. Shozi, I think it might be, I'm actually seeing some follow-ups as well on the chat. It might be optimal that we deal with one issue, close it, and then move off it.
Okay.
For instance, if you don't mind, we'll come back to the issue of generation, because although you may have spoken largely around the grid code, the technical side, but it's the jurisdiction that we have not responded to, which Voice has already spoken, has already indicated on the chat. But can we close the first issue? There is a further question to you, Mr. Murati, that do we need to alert the public? I'm not sure if you saw that, if we can maybe deal with that. Mr. Murati, you saw the chat comment from Advocate Stock. Okay.
Chair, you can move on. I think
Let's move on to that.
Please.
So that's a follow-up that we need to conclude. Can we then move to the generation one? I think the first issue from, and I was going to comment on this, but I think the way that we first captured it quite succinctly. That says, do we have jurisdiction in terms of regulating storage? The answer is to the extent to which we're regulating storage as a generation facility. Generation itself, yes, generation itself is in fact, the definition of generation in the Act, it says by any means. So to the extent to which we are regulating, we'll be regulating a battery for operation of it as a generator. NERSA definitely does have jurisdiction, and I think Vulswa captured it very nicely there. So I thought maybe I'll just start there, and then I know that Madam Aseti has a follow-up on that. Can we then maybe, if we can hear your follow-up on them?
Thank you, Chairperson, for the opportunity. Chairperson, I don't think that we have convinced each other in terms of ensuring an alignment in the interpretation and in the approach with regards to storage. Storage is storage. The primary purpose is to store energy. And generation has its own sort of a definition. We can't try to sort of find some means of interpretation of what the law says in terms of our jurisdiction of issuing licenses for the operation of generation infrastructure. And where the law is not giving us clear powers for the operation of storage infrastructure, we can't then say that simply because there's some generation and therefore this one specifically is for storage facility, and we don't have those powers explicitly granted to us in the law. So at least from my side, at least for my comfort, it is important for me to at least see that we do have such powers clearly stated in the Act, not to try and find means of saying, well, it will be used hand in hand with generation, and therefore in that regard, it's sort of an ancillary thing because the main thing is generation. The fact of the matter, storage on its own, it's a substantial activity, and it has its own infrastructure, and that infrastructure may be infrastructure that is required to be regulated so that there is a regulatory framework on that infrastructure. Why do we then have even the grid code that then seeks to talk about how we manage that infrastructure, how we regulate that infrastructure? Yet on the other hand, we then say that let's talk about generation. This has to do with generation. Let's not look at it in isolation, and let's look at it from a lens of generation. I do have a challenge with that, and I'm not saying that we should not take a decision if, for instance, we acknowledge the critical role that this infrastructure will play, and because the Act is not so clear in terms of giving us the powers to grant licenses to operate storage infrastructure, to the extent that this is going to play the role of stabilizing the grid, and we also have the grid code. Maybe, for me at least, it will show that there are some means of dealing with this aspect. However, it does not prevent us from then making some recommendations to the minister to at least make some legislative changes to allow the regulator to have a clear, very clear powers of licensing the operation of storage infrastructure. At least for me, that is the position that I believe we should also articulate. Otherwise, I'm not comfortable with the fact that it says generation. It doesn't, differentiate in terms of the means. This storage is storage. It is not generation, but it supports that generation. So for me, that is the point that I just want to convey. Thank you, Chair.
Thank you, Madam Massetti. Mr. Mkhize, I note your hand, but I would like us to close this matter. Mr. Murati, I would like to invite you to respond to this issue of storage. But before you do, I think for me, it must be the point, Madam Massetti, that I would like to maybe raise two, is that battery storage might be something that we're new at, but we've been storing energy by form of pumped hydro for a long time. But the point is that I think the colleagues are wanting to raise is that in terms of our mandate, in terms of the law, we license generation, transmission, distribution, and maybe to some extent some form of reticulation, whatever, and trading. But those what our mandates are. We're supposed to actually, but storage as a load in terms of the facility itself, when it is storing energy, that activity, when storage is acting as a load, when that facility is a load, we don't regulate the load. Whether that load is a smelter, or that load is a stove, or that load is a geyser, or whatever that load might be, we do not regulate the load. The only thing that we regulate is if that facility then begins to generate power to the extent that it exports the power into the grid. Now that is what we then regulate, in which case that is technology agnostic. It doesn't care. The definition of generation is such that it says by any means. So even if you're generating with using OCGT or using a pump hydro or battery or whatever, to the extent to which you are generating power, what it's simple saying is that you then need a generation license, unless of course you are exempted in terms of Section 9, and maybe you just come for a registration, or you're exempted because you are self-generating or you're less than 100 kilowatts. So it is those things, I think, that in essence, what generation is about. So this item here, in terms of jurisdiction, is that to the extent to which storage is a load, we don't regulate that at all, because we don't regulate any load. But to the extent to which that storage facility is now used to generate power, then it is a generator, in which case then we actually license a generator. That's where I would understand. But Mr. Murati, if you can just maybe just raise your issues on this, if there's anything that I may have left out, to close this issue, and then of course we can touch on the issue that you've put on the chart so we can move on to the other items. And I know to Mr. Mkhize.
Okay, I think you have summarized it correctly in terms of maybe one could just add that the consent should be the regulatory outreach in terms of our scope, that the law as it stands to date does not recognize that generation could be from any form of technology which the law has not identified. That any aspect, that any facility, any technology that could generate electricity remains in the domain of whoever might be regulating such. But for NERSA's purposes, the mandate it's that the moment such a technology starts generating electricity, the ERA then becomes applicable. And in the instance of storage, the storage becomes a technology. But the mandate of the regulator starts when that technology starts evacuating electrons into the grid. That is when the issues of licensing comes into play. That is when the issues of regulation through licensing or regulation through registration comes into play. It is not, and I think one would be maybe referencing it to say, when you look at the Gas Act and the petroleum pipelines, the referencing of storage comes in as an activity that is within the domain of NERSA for purposes of those legislation. And unfortunately, the ERA does not deal with the issue of storage. So there is that distinction between the three industry legislations with regard to the mandate of NERSA. So I think we need to recognize that particular. Otherwise, when we start involving ourselves in, we might be having a scope creep in terms of the provisions of the law. I think that is what I can add to what you have already highlighted, Chairperson.
Okay, thank you. Advocate, I assume that you are satisfied with the answer as provided by Mr. Murati on the chat. If I can then maybe take Mr. Mkiza's follow-up question. Mr. Mkiza, apologies for the delay, sir.
Chairperson, I'm following up on the issue of process. My understanding is that there are certain issues that we are going to flag, and these issues, they need to be dealt with by the team. They may not be fully exhausted here and now because they deal, for example, the issue of storage vis-a-vis when you look at generation and how then you decouple that and have the issue of storage separately. It's a matter of how we then deal with the matter internal as NERSA, also in feeding back to the policymaker being the department. But I take it that of focus for me will be the issue of raising questions that the public will then have to respond to, so that they assist, because we are saying we don't have the monopoly of wisdom in dealing with this issue, and therefore we need to get their input for the concurrence with the minister's determination. Also by Mr. Shows in terms of how we are dealing with it. That I take it as just to serve to explain, so that even if there are questions to that effect, they can be dealt with. But of importance is to be able to craft the consultation paper and the questions such that we elicit that kind of response from the public to talk to the issue of grid congestion, grid stability in view of the increased generation that we are foreseeing. Also, taking also into account the intimate nature of that in the absence of concomitant battery storage, the flow of electricity from these facilities. I will leave it at that so that we can be able to move with speed towards the decision.
Thank you. Thank you a lot, Mr. Mkiza, for the guidance. So, Mr. Shozi, I guess also colleagues, perhaps, thanks for the guidance, Mr. Mkiza, because I think we're falling into the trap of trying to, convince ourselves here when, in fact, perhaps we will get that when we are making a decision. But at this stage, we are seeking. So questions have been raised. To the extent that colleagues, we can respond to them now, or just take them on board and put them on the consultation paper, or even the questions that have been asked by members that they should go onto the consultation paper to the extent possible. So that is the issue, and thanks, Mr. Mkiza, for that guidance. So we will leave that issue. I think it's the issue of generation, for instance, it's been discussed, but I think it would be useful, Mr. Shozi, if we can then pose the question to the same question as well to the stakeholders, so that the stakeholders themselves can then maybe afford and give us their own interpretation of the question at hand. All right, if we can kindly continue. I know I disturbed you. If we can kindly continue, perhaps what I should then just do is limit follow-ups at this stage. If you can continue, Mr. Shozi, with the assistance from your colleagues.
Thanks, Chairperson. I'll try to be quick on this one. Yes, we will take, as I've said in my opening remarks, to say after this meeting, we'll try and improve the papers as will be guided by members. Any other issues that will have need to be discussed in detail will go to in our draft RFD. Around the position, if you have taken any position on this concurrence, on this determination or consultation paper at this stage, no. We have made that disclaimer to say we are still seeking comments from the stakeholders. When we are doing our analysis, that is when we'll be making our positions the proposed positions for the regulator to consider. The timelines, I think Mr. Muradi has talked about that, 14 days or 15 days. It's in line with the legislations. We know these are 3 consultation papers. Unfortunately, we need to align ourselves with what other departments are doing. So we are not out of legislation in terms of what we are doing. We are expecting stakeholders to also be able to provide comments within the 14 days as legislated. Capacity, yes, it's going to be difficult, but we have done difficult concurrence before in a short space of time. We have put together a team that will be ready immediately after the closing date of the comments to work flat out and make sure that we produce quality analysis within the constrained period. So we are confident that we will be able to meet the timelines as we indicated in our submission. Thanks, Chairperson.
Thank you. If I may add on your responses, Mr. Shozi. The first one, Mr. Mkhize, you asked whether are we on the critical path. The answer is yes, because the IPP office will not be able to initiate the process of issuing the tenders until NERSA has concurred. And so are we on the critical path in terms of decision? The answer is a definite yes. And hence why any delays from our side actually translate into a delay in terms of the procurement process. And so that is the first answer to your question. Now, the issue of being able to move from 14 days to 21 days, Mr. Mkhize, the challenge is that the assumption in the proposed timelines is that there won't be a need for a public hearing. However, having said a comment and publish and comment process, but if people have indicated a request to actually for them wanting to actually to come and make a presentation, we will have to accommodate that. So it is likely that although we're going for 14 days, but if there is any request for a public hearing, that we cannot ignore. So that may substantially add a few days, but our target, which is what we are then proposing, is that target of 14 days in terms of publish and comment. But if stakeholders request a public hearing, that will add another few days, perhaps another 7 days. Unfortunately, that is not something that can be avoided. I note your hand, Madam Asiti. Can I just respond to and finish the thoughts that I may have? The issue I think that had been raised earlier around the problem with Section 34 or the issue with Section 34 is something that we do need to note that unfortunately it comes with obligations on the regulator. Section 34(3), especially on the tariffs, that we've in the past been misunderstood as that tariffs that emanate from a public process, a public procurement process, a bidding process, that NERSA subsequently still has to actually set those tariffs. I think because we don't, that the idea is that the process that emerge from from a bidding process would be the best practice. You can't do better than that, and therefore the regulator does not then go through a process of setting tariffs. So that's the other implication, but we need to understand those implications. Perhaps we may need to include them in the consultation paper so that people understand the binding nature of that section 34.3 on NERSA once a particular determination is made. You've raised the issue, and this needs to be put forward. I think you've raised the issue, Mr. Mkhize, around and Madam Pungose, of the use of other state-owned entities in respect of as a buyer. The challenge, remember, the issue here is that how do those people that are procured, how do they get paid? At this stage, a single buyer, being Eskom, takes basically signs the PPA and transfers that revenue requirement straight through as a pass-through. Now, as a pass-through, and that's how they get paid. But in the event that a buyer is somebody else other than somebody that has got an ability to recognize that cost, that PPA cost, as a cost and pass it through. The question is, if it's somebody else, how would they be able to actually recoup that cost? So clearly something that we should be able to put through to the public for comment as well. But we have to recognize the challenge that it can't be anybody else other than somebody, well, at least in the current regime, it can't be anybody else other than somebody that has got an ability to then recoup that, to actually get the revenue from that. So that needs to be considered. I thought we should add that. So those are the things that I wanted to add before we proceed. Madam Maseti.
Thank you very much, Chairperson, for the opportunity. Chairperson, I must just express my discomfort with the timelines. Reason being that, first of all, we must always affirm our independence. We must not take decisions in haste. We must also not reflect in our decision-making process that we have taken pressure from other entities in the way that we have processed our decision. That should not be reflected in the process of taking our decision, because that will actually undermine our independence. And undermining our independence, it will also expose us to risk of being challenged on procedural unfairness in terms of our processes. We have lost cases in the past because of merely just the process. So I would like us to not just deviate without even convincing each other before we take this decision, at least today, because the decision that is sought from us is one that requires us to approve the indicative timelines, of which indicative timelines deviate from the statutory 30 days prescribed. Now, there are certain factors stipulated in PAJA when we deviate from the timelines, and we must answer each of the 5 factors as to what are our reasons for doing so. And in this submission, we have not identified the 5 factors and provide the reasons for the deviation. But again, even when we manage to provide justification in terms of the 5 factors that are prescribed, I think it is again important for us to balance the substantive nature of the issue that we're dealing with here and the interest as well as the impact of this to the public out there. They may agree on some, because we're dealing with at least 3 of these concurrencies. And they might agree, as we know, that others may support some of the sources of energy. They may not support the others. And that opens up the risk of us being challenged on the basis of process. And we also have this looming, judgment, the Earth Life judgment, which criticized us heavily for rubber stamping. Now, if we shorten our timelines simply because we really need to rush this and take out decisions in haste because we're trying to fit into the programs or the timelines that are set elsewhere, and in so doing, we are likely to compromise the quality of our decisions and our processes. That, for me, I would say it will be a risk, and we should at least avoid that at all costs, at least to protect the image of the regulator. There is no need to take 90 days. We can reduce that 90 days, but I'm more worried about our compliance with the statutory timelines of 30 days, and where we actually fail in the submission to actually provide justification in respect of the 5 factors that are stipulated in PAJA when one deviates from the statutory timelines. We fell short on that. And where I'm sitting, I do believe that we need to follow the timelines that are prescribed by law, unless really we have convinced each other with regards to the reasons. And in this meeting, there is nothing that actually came out as the key reasons or critical reasons for deviating, and such reasons must comply with the 5 factors that are stipulated in PAJA. And that, for me, is a problem if we're to allow these timelines to be the ones that are published. Thank you, Chair.
Thank you, Madam Massetti. And I guess this issue, Mr. Mkiza, you're going to talk to, because as you indicated, in fact, it is the one issue that we need to convince ourselves in terms of the timelines. So over to you, sir. I assume that we are following on that as well.
Thanks, Mr. Chairperson. In fact, it's exactly that from my side to say, all the other issues, actually, they are there to enhance the consultation paper and pose the questions in a fair manner. Even the issue of the SOCs. All I was saying is that if you make it wide enough and give people a chance to comment on that, it's also further enhance and enrich our regulatory performance. Having a question around the timelines, being informed by the fact that we're dealing with 3 determinations here. If we had one determination, there would be some understanding, but still that understanding must be informed by the reasons provided in terms of the PAJA provisions to deviate from the statutory timelines. That is one. And when I'm talking about critical path, I don't mean a critical path imposed by maybe the IPP office or whatsoever. I'm talking about looking at the whole process to say that if we doing this, the whole process of getting the electrons flowing, how will that, couldn't this be managed differently? I'm talking about that. That is a kind of justification that must be presented. I'm not sitting here not for doing things expeditiously, but we need to also bear in mind that we are here to solicit public comment. If we publish on Friday, then people actually have got more like a Monday. We also must take into account the need to aggressively communicate this, that is, publicize it on our platforms as well, just to get those inputs, so no one can say that he's been left behind. But my concern remains in terms of the proper justification. I cannot sit here and try to find reasons, then provide reasons, failing which one will have to revert to the statutory timelines. I was looking at the 21 days and also saying that if need be, we can even have a public consultation with, a public hearing within the timeline, so that we can be able to then buy some time, because we could have a situation even that we've got the 14 days, and then there's a request for an engagement beyond that 14 days, which at the end of the day brings us back to the 30 days. So I was thinking that if we plan things and have that within the days to comment, have that public hearing, it will help the process, and we are sure that there won't be any kind of comebacks, because everything has been done accordingly. Because even if some people make some the allegations against the process, even if it is maybe on the side of being a bit frivolous, it's going to be hard just for us to brush that aside and then find ourselves also being delayed by even further. That's all I'm saying, is that we cannot rule out that if someone decides to be very petty and or decide to be frivolous in a way, it's going to hamper us. That's all from my side. Thanks, Chair. Sorry for taking long.
Thank you, Mr. Mkhize, for the input, and maybe just for us to get a decision here. Would it be possible? Because I think the issue at play here is whether we give stakeholders 14 days. Well, firstly, we give stakeholders what is prescribed as 30 days, or we give stakeholders what proposed as 14 days, or we give a compromise of 21 days. If I may then maybe just direct us to that. If we're to move to 21 days, with the view that if somebody wanted to actually have a request of us to have a public hearing, we can also still have a public hearing within 21 days. Because I don't think the decision-making processes, our own decision-making processes, the only thing that would be asked of us is to have special meetings, and hopefully special meetings that do not compromise the actual number of days that we are given to actually consider reports. But that's where, in terms of us making decisions. But what the colleagues are here for is to ask, to say, do we consult for 14 days, or in fact normally would consult for 30 days plus allow for a further 7 days or so for a public hearing process. But in this particular case, the proposal is for 14 days. But what I'm hearing, Mr. Mkhize, for instance, saying, why don't we go for 21 days? Can I just maybe, if I could, I don't know, say by, can I, for purposes of us getting into a landing, can I maybe put it to members that if we were to look rather not allowing 20 days, but to 14 days, but to allowing 21 days, would members be comfortable with that proposal? Because that can still be changed accordingly. By show of hands, members, would members be comfortable with that position? That is still not a full 30 days. It's still not a full 30 days, but it's not 14 days. It's a compromise figure, which is 21 days. I see a hand up, Madam Pongo. Thank you for that, Mr. Mkhize and advocate. I also support that. I think if we could have a landing, yes, Mr. Mkhize, I think as an enhancement on the document, the team needs to indicate why our process is in fact on the critical path in terms of getting electrons onto this. Not about the IPP office, but it's about the whole process. That unfortunately, still need to go to tender, people need to prepare their bids and so forth. And that unless we've concurred with this process, that process does not start. So, but the team needs to enhance the actual consultation paper to indicate that agency, and the team also needs to indicate in the consultation paper why we're not going for the full 30 days as in PAJA, and why we are going for 21 days as in PAJA, as allowed in PAJA, but with the necessary justification why the 21 days. Mr. Shozi, I'm hoping that is quite clear to you.
All is in order, Chairperson.
Thank you, members. Okay, now there was a sub decision, but the actual decisions that are sought from us are on paragraph 14. Paragraph 14, which is to note the actual request for concurrence. Number one. Number two is to approve the publication of the consultation paper as amended, as members may have contributed. Please, if you can update the consultation paper accordingly. Then recommend to the ER to note the consultation paper. But in terms of D, to then change the indicative timeline, Mr. Shozi, from the original 14 days, so you need to accordingly change the dates from the original 14 days in terms of for publishing to 21 days. And then, of course, the question that was asked whether you have the 3 days would be adequate for you in terms of analysis, but clearly as indicated, there's nothing stopping you from doing parallel analysis as soon as you receive those comments, unless of course they all come on the eve of the closing date. But assuming that they will be trickling in, as they trickle in, you'll be able to analyze that. But then you then analyze those that come on the last day over the 3 days. It does shift the actual dates for the special ELS that may be required, if one would indeed be required. And then perhaps if that shifts that, we may actually be able to go for the normal ER, depending on the days, on how this thing push it close. It might push it closer to the ER. But I would suggest that you add a workshop there as well to allow members to be able to engage, to fully engage, if you could, between the ELS or before the ELS, have a workshop, or between the ELS and the ER. So I would suggest to actually add on that. So that is the decision that is sought, members. By a show of hands, will we be able to actually vote on that as captured? By a show of hands, members. I think I hope we have captured it. Members, thank you, Madam Pongose. Mr. Mkiza, I see your thumbs up, but if you can just show your hands. Madam Maseti, Advocate Sitole, thank you. Mr. Mkiza, I saw your thumbs up, but can I see your hand, please, sir? Okay, still a thumb. Thank you, Mr. Mkiza. Now it's your hand. I also support that decision. Thank you. I think the other two will go pretty quickly as well. So we're not going to deal with the issue of time on the other one. We're just going to actually, if Mr. Shozi, you can just go into the next item. And maybe just Mr. Mkiza Jr., if you can just highlight what is different with this one, and then members can then be able to then add if there's any further guidance from members that they may want to add. Over to you, Mr. Shozi.
Yeah, I think you've said it well. Mr. Mkiza, we can just take this one and highlight what is different from what has been discussed, just the specifics. Over to you, Bob.
Thank you, Mr. Shozi, and thank you to the members for all the comments, which we will include in the reason for decision. So thank you very much. With regards to the next determination, it's we are dealing with a generation capacity of 3,000 megawatts from gas. So, as members said, some of the capacities might attract attention and a response from the public. And I think particularly on this one, there will be an interest. So basically, on this one, Eskom Holdings will be the developer and procurer of this equipment. And it's emphasized that this will be a combined cycle plant, which will be developed in collaboration with a government entity such as Transnet that will basically cover the issue of logistics in terms of bringing in LNG, which is liquefied gas, which will be brought to a facility that will then convert the liquefied gas into gas and then run a power generation plant and then gas will also be distributed from that point. So maybe just to highlight what is different about this particular presentation, firstly, it's that it's a dispatchable capacity, of which if you are going to add close to 15 gigawatts or 15,000 megawatts of variable capacity, you do need to have a solid capacity that is dispatchable, and this is what gas is. So maybe just to also maybe add to to add a dimension to the explanations that were given earlier, the fact that these capacities, both the one that I've just presented previously on the renewables and this one, is that they are on the IRP 2019, and that means that thorough studies were done to determine these capacities, and so that does give us a comfort that these were properly modeled and studied. And as Mr. Shozi did say earlier, even when these capacities are going to be commissioned onto the grid, before anything happens, further studies are done again to determine that the conditions are still conducive for these capacities to be added. So there is comfort with that. And and then in terms of maybe just going through the details of the paper, the technologies from gas, so we are asking stakeholders to comment on this technology. And then there is a part in the determination that talks about cost recovery. And on this, we are asking stakeholders to comment on the most appropriate way of recovering costs in terms of the project life cycle, the capital and operating costs that will be incurred over the life of the project, how they will be recovered through tariffs, and so forth. So that is adequately covered in the stakeholder comments. And then in terms of the procurer, Eskom is the procurer, and we are asking members of the public to comment on Eskom being the procurer and also possibly the developer of this capacity. Of course, in the additional information that was supplied by the DMRE, they did state that lessons were learned from Medupi and Gusile, and such will be avoided through contracts that are structured such as EPCs, engineer, build and construct, which are more closed and do transfer the risk to the developer. So that was covered adequately in the feasibility study that will be provided to members on request. So that covers the procurement, and then the timelines of the project. It says in the determination that this capacity should be developed at least before the year 2028. And so we are also posing questions there whether this highlights the urgency of the need for this capacity. I will not touch on the deliberations, as we have already spoken at length with regards to the timelines. And so I can conclude by asking members to draw their attention to section 14 of the paper, of the submission, to note the request to concur with the proposed determination, to approve the publication of the consultation paper as attached, and also then to recommend to the ER to note the consultation paper, and lastly, to note the indicative project timelines, which we have already covered. With that, Chair, I will hand it over back to you. Thank you very much.
Thank you, Mr. Mkhize. Members, any particular questions, comments in respect to specific to this submission? By show of hands, members. Madam Aseti.
Thank you, Chairperson. I've got 3 issues to raise with regards to this one. The first one relates to the issue of the cost recovery mechanism. That this paper, this document touches on. Perhaps it is also important to just to balance the approach here to find out about the suitability or the desirability of continuing with the current recovery mechanism, cost recovery mechanism that is used for other sources of energy. So that when the question that is asked about the cost recovery is not sort of a secluded or aloof question, but it is a question that fully appreciates what the practice has been with other sources of energy that are procured by Eskom, and where Eskom needs to recover the cost for this other energy that it purchases from independent power producers. So it will be the same thing also here in terms of, therefore, just making sure that in line with the current cost recovery mechanism, should NERSA continue with it? Do you think that it is still suitable that NERSA continues in this kind of a project, continues with the cost recovery mechanism that it has been using? So there is no sort of linkage. It's sort of, the question is asked in a manner that sort of does not seek to recognize that this has been done before, and it has been done with regards to other sources of energy. But when it comes now to this particular source of energy, do you believe that it is something that NERSA must continue using? Is it still suitable, or should there be a different pricing or cost recovery approach that NERSA should then adopt, and then give reasons and also maybe the impact of that, so that we sort of balance that, and also the risk of preventing the investments that are sort of coming from other sources of energy. Then the second thing that perhaps we need to look into, Chairperson, is the intention of the question around the timeline, so that we are very clear what is it that we would like stakeholders to sort of answer and give guidance on when it comes to the timeline for this project, for the gas project. When we put the question about whether or not it highlights the need for this procurement, I don't know where we are getting there. Are we highlighting that if it says that 2028, does it mean that 2028 is too far, or given the challenges and the needs currently? Are we trying to say that in the way that we have articulated the question, or are we trying to perhaps put a question that seeks to at least bring the timelines sort of forward, so that then it can justify the need to have or to procure this or to have this the gas projects as part of sort of the emergency a procurement, or a procurement that seeks to deal with the critical shortages, energy shortages that the country is encountering. I just want to understand where we are getting with that kind of a question, because when you ask the question, you ask it so that the stakeholder may respond and get a sense and provide some guidance as to what may be an appropriate approach. And then the other question that I have relates, I think it's paragraph 3 on page, I'm going to use, the document doesn't have pages, but it will be paragraph, if you look at paragraph 4.4, and then you go down, because there are no pages here, so I'm struggling a bit. You go to paragraph 4.4, and it's got sub-paragraphs. Those sub-paragraphs is 1, 2, and then you go to the second paragraph of 1, sub 1. Yeah, the problem with the numbers, I think the numbers must be fixed there. It talks about, it relates to the issue of affordability of electricity prices. May we try and sort of unpack that, and that goes also with the question that is on question 3, subparagraph 3, that talks about the shocks that affected the prices. I think it's the demand shocks and do not experience electricity price shocks. What are we trying to say here to stakeholders? Is it not? Are we not putting this in a negative form to try and discourage the very same procurement here that minister says it must be procured, but we're now saying when it's gas, look into the prices of gas, and therefore this is going to come or will have a sort of an effect on the prices of electricity, and therefore we must make sure that electricity consumers do not experience electricity price shocks as a result of additional capacity for gas. This really cancels the very same project that minister says we must concur with, because now we take a different approach, and we have not taken that approach when it comes to other sources of energy, of which have their own challenges and issues of cost that if you were to check and do your research properly, you will see that there are some other costs that actually other experts in the industry, they actually go against some of those other infrastructure that support the other sources of energy. So why particularly on this one, we put questions in the negative and trying to discourage and say, you are going to inherit some form of price shocks when it comes to gas, and therefore that exposes electricity consumers. But we didn't undertake that very same approach and critique when it comes to other energy sources. So that, for me, I think it is a bit of a challenge, because we didn't question issues of cost. That will also, even with those other ones, apart from the batteries and all of the other shortages with regards to the battery technology and the cost related thereto, as well as actually other investment costs. If one were to say, let's take this capacity on renewables, and therefore if you were to acquire renewables, then there will definitely be other substantial costs that are attracted, and some of which will be cost of investing in the network, and that must be recovered. So we also don't look into such things. But when it comes to this particular source of energy, we raise such negative issues that seeks to cancel the very same procurement that minister says we must concur with. I would like to understand why is that, and what is the implication of putting such negative statements in the document. Thank you, Chair.
Thank you, Madam Aseti. Mr. Mkiza?
Thanks. I think, sorry, just for the sake of record, I think just to say that this determination has been put forth to us for us to consider, and if so required, we then concur, not necessarily as an imposition from the minister's side. Maybe just a use of the language sometimes. I think the record should just consider that. But then my questions actually, I would like, I think in a definition in terms of the definition in the consultation paper, put the issue of dispatchable and non-dispatchable as what that means, because it gets also linked with the issue of base load. And then the question that then comes to bear is, how do you phrase that the question on the timeline? The way it seems to me is that you're thinking that the period can be compressed. If you can just then, I would say that maybe rephrase that question to state that maybe to say what is the shortest timelines, or what are the optimal timelines within which the member of the public believes this or thinks or expect this generation capacity to be established, and provide reasons therefore. So if you can just consider reviewing 3.2 to that effect, if you mean the timelines are not reflected as urgent, if the timeline is out to 2028, right? So that is the first one. And then two, I think there should be a question that also looks at how
Mr. Mkiza, I'm losing you there. I'm not sure that's just on my side.
I can't hear him as well, Chairperson.
Oh, my goodness.
There's something wrong with his connection, Mr. Mkiza.
It's always better in the office,
can
Mr.
you-
Mkiza, where we actually missed you completely. You may have to start again with this question. We did not hear you.
Oh, is it now? Is okay now?
Yes, we can hear you now. Please proceed, sir.
So I must start with the question, or must I start right from the beginning?
No. Just this
No.
question.
Where he
Yes,
was at after 3.2, Chairperson.
Yes,
He was
yes.
proceeding from there.
Oh, after 3.2, yes, where I said I must just rephrase it
Yes.
accordingly. We're struggling. I've even tried my own router here, but it seems to be having problems. One, I think we've dealt with that. And then how would we benefit the economy from the use of the gas? I'm thinking that because we've always looked at electricity as an end customer, seeing that gas could then also pose a benefit, which will also go towards looking at maybe the positive side or upside of using the gas. And then I think we should also pose a question that is related to the issue that Madam Asset has raised. But for me, you can't talk of gas which we don't have our own domestic resources here, and not talk to the issue of the rand-dollar exchange rate, risk how that could be managed, which would be issues of hedging. And I think that a comment also on gas as a transitional fuel, because one thing I've seen in some quarters, gas is viewed as if it's not actually a better solution as compared to the other fossil fuels, which the IEA has affirmed numerous occasions, citing that we talking of the golden age of gas and all of that. So I think that we must raise an issue, a question to that effect. And lastly, we must also define dispatchable and non-dispatchable for the sake of the members of the public to have a clear understanding, and then be able to then comment accordingly, taking due regard also of the need for base load capacity. Thank you.
Thank you, Mr. Mkiza. Colleagues, maybe just one addition from my side. By the way, Mr. Shozi, I think from where I was reading the comments by members, they are largely for enhancement. And mine might also be about as well. The question I think, Mr. Shozi, here is one that says, I'm not too sure to what extent we can ensure that we don't get a repeat of the risk mitigation project, where on the electricity side, we deal with the electricity license, and then subsequently we then deal with the feedstock. Is it possible that in procuring this time, that the actual procurement is for a facility, the whole precinct, which includes gas supply, associated infrastructure, and electricity? That in the tender itself that goes out, that is written such that it's a one-stop shop, such that when we consider, for instance, as NESA, when we consider licensing, we just consider licenses one time. We don't actually have to deal with these two. Otherwise, it actually elongates the process and creates a lot of pitfalls. So I'm just saying, in terms of the of enhancement, maybe it's something that when we are doing the actual RFT, we can review properly, such that when we then propose to the IP or when we concur, our concurrence could then request that the minister looks at this as a facility, which is basically got its energy storage, which is upstream, and the actual generation facility looks at that, and that's what goes out to tender. So that's what I would request, Mr. Schultz. But over to you. I think a lot of the questions were, or rather, they were more for guidance and actually enhancement. But can I hand over to you?
Thanks, Chairperson. I agree with you fully. We have been guided by members, especially on the issue of the cost recovery. We will enhance on that one so that we reflect what the members have guided us on. Around the issue of enhancement, again, that question, Mr. Mkiza and Ms. Masetti asked a similar question. We'll craft the question such that we get a sense from the public if the plant has to be commissioned in 2028, will it serve the current crisis? Also, I indicated in my initial comments that we have crafted this consultation paper. We are running parallel consultation with gas colleagues. All the question or proposed questions by the members in relation to gas, we will be consulting our gas colleagues so that when the paper goes out, those questions are incorporated. But we take note of all the guidance that we have received. To appreciate, will enhance the paper as such. Thanks, Chairperson.
Thank you. As Madam Masetti was asking, please maybe do include the question that I was posing on looking at this as a precinct rather than piecemeal. Actually pose it to the public as well. Advocate, I see your hand is up, ma'am.
Chairperson, I was just going to say that the team must also take into account the comments made on the timelines in the previous submission, in this one, and also in the next one. Thank you, Chairperson.
Thanks, Madam. All right. With that, I think and please note the further comments on the chat, Mr. Shozi. For instance, the issue of cost recovery. The proposals for alternatives. I think also I would so that we are one NESA after all, and it's one body. I would as well, if it's possible, look at the proposal in terms of the price determination methodology and choose the proposed approach to see whether you can't extract any questions there that might assist, or rather the framework as well as the questions that may assist stakeholders in terms of assisting us in responding to our questions. With that, members, the decision that is sought, and taking into account the previous decision, especially in terms of the timeline, and the team will enhance the document as directed by members or as advised by members, and also taking into account any input from GAR in terms of this one. Especially in terms of writing some of the things in a positive framework and expanding on other issues, including the actual definitions, dispatchable and self-dispatching, or rather non-dispatching. I think the term that is used is self-dispatching rather than non-dispatching. But we need to actually have those definitions. So let's not assume that everybody out there understands our language. So those are all enhancements. So, but with that, colleagues, the decision that is sought is on paragraph 14. We are requested again to note the request for concurrence and to approve the publication paper, and with those enhancements that have been proposed by members, recommend to the ER to note the consultation paper and note the indicative timelines, taking into account all of the discussions that happened in the previous item. With that, by show of hands, members, if we can agree to that. Thank you, Madam Maseti, Madam Pungos, Mr. Nkize. I also support and thank you, Advocate. So you've got a decision, Mr. Shozi. We've got 6 minutes to handle the next one. Mr. Shozi, over to you. It should not be as complicated as this one. Thank you. Over to you.
Thanks, Chairperson. This one is it's 1,000 megawatt coming from cogen, biomass, and landfill. Mr. Mkize will take us through and use the same approach like he has done on the previous presentation. Over to you, Walile.
And please, Mr. Mkize, just focus on what's new, only what's new. Thanks.
Okay, thank you, Chair. I will do my best to just maybe provide a small background, and then we'll only stick to what is new. This determination is to increase capacity on an immediate term by allowing Eskom to purchase capacity from existing IPPs. I believe that it replaces the short-term power purchase program that we presented to this committee last year, which did not materialize for some reasons that we presented last year. So if you look at the 3 determinations, this one is immediate, the other ones are medium to are short to medium term. So yeah, that would be the background. And then with regards to the technology, this is coming from co-generators, which would include companies like the paper mills such as Mondi, and also maybe the the processors of sugarcane and so forth. There's also biomass and landfill. These are just capacities that will be available from suppliers that are already using that capacity but have extra, so that they can be able to provide to the grid. So that will be the technology, and then the buyer of the capacity will be Eskom. Eskom is the one that requested to have this program around January this year. And then with regards to timelines, I will not touch too much on that because we've already received guidance to enhance that question. And then on deliberations, we will not touch on that again because it has already been covered in the other submissions. So to conclude, we are asking the ELS to approve, or rather to note the request to concur with the proposed determination, and then to approve the publication of the consultation paper with the enhancements that will be provided, and then to recommend to the ER to note the consultation paper, and lastly, to note the indicative timelines, which we have alluded to earlier. With that, Chair, thank you very much for the opportunity, and I'll hand it over back to you. Thank you.
Thank you, Mr. Mkize. Members, we have the item before us. Any additional comments, taking into account that everything else that we raised in the previous 2, those that are applicable here, would actually be considered as well. Madam Maseti.
Chairperson, as an additional comment, and as you know that even in the previous ones, the STPPs that we actually considered, we have always got stuck on the issue of the cost recovery, and where we have accommodated this in our multi-year price determination. So I would like to advise that I think the questions, again, there's no pages here, but I can again maybe refer to paragraph 4.4, and then it has sub paragraphs. So if you look at those sub paragraphs that relate to cost recovery, they need to be rephrased a bit so that we get sort of a better guidance on the cost recovery. We need to rephrase it. For instance, the question that we posed to stakeholders there, Chairperson, the way it's a huge paragraph, the question itself, but let's just break it maybe into two, that question, so that we can have a better response and guidance, perhaps, or proposals from stakeholders when it comes to a cost recovery on these kind of projects, the cogens. As you say, this will be a sort of excess energy in many instances, so it's perhaps readily available. They want to sell that excess energy that they're using for themselves, maybe sell it, so it will be much easier. But let's look into some of the words that we have used there in terms of the fair returns and all of those things. Let's just tweak it, Chairperson, and also, you know, have a context when we now talk about issues of electricity price shocks and stuff like that. You know, there are things sometimes that are not suitable for this specific program. So we tend to have generalized some of the questions, but sometimes they're not suitable to give us better answers for better processing of a particular a project. So if we can just check those kind of questions, Chairperson. I think also the one on paragraph 4.4 sub 1. Some of those questions, they need to be rephrased a bit, Chair, just to assist us in getting meaningful responses from stakeholders and proposals. Thank you, Chair.
Thank you, Madam Massetti, and that's an enhancement, Mr. Shozi. It's about enhancing the actual response, so it does not solicit response. Mr. Mkize, question, sir?
Thank you. My previous comments hold, and I think we just need to enhance the definition side to, like, for example, include what the biomass will be, what is cogen, you know. That will help, because we've actually retained the definition of photovoltaic energy instead of actually zooming into those that are really applicable. So just to help, because it's not about the potential generators, it's about the public as well, to be able to understand what we're talking about and be able to then comment, because these things, in one way or another, they are going to affect the general public. Thank you.
Thank you, Mr. Mkize. Again, that's for enhancement, Mr. Shozi, just enhancing the definitions section, that we actually, all of the matters that we may understand what they mean, but we are talking to the general public, so we need to, when we're talking cogen, what is it? Define it, and so forth. But I don't think there's anything else. Mr. Shozi, do you want to respond to anything, or are you comfortable that it's for enhancement?
I'm compatible, Chairperson. Thank you.
Thank you, Mr. Shozi. With that, colleagues, I think it then takes us to a decision. The decision, I'm not going to repeat it, as Mr. Mkize Jr. has actually explained it, but it's on paragraph 14. By show of hands, members, if you are in agreement with that decision, with the recommendations. Thank you, my Advocate Sitole. Thank you, Mr. Mkize. Thank you, Madam Pungose. Thank you, Madam Massetti. I also support.
Chairperson, just for the record, so that it is clear that the sub decision number D there, it will not carry as is. It needs to be amended in accordance with the previous comments.
Yes, thank you, Madam Massetti. Just for the record, as indicated, that whatever that we agreed on in terms of the first item, it so applies here as well. Thank you. Mr. Mkize, lingering hand? All right, thank you. By the way, may I suggest that when you're in the office, connect via LAN. I find that it works splendidly for me. I never connect on Wi-Fi. Yes, but I'm just saying that when you're in the office, please connect via LAN. I find that it works very well for me. The Wi-Fi is in the office.
I tried it. It failed me.
Okay.
It failed me that even time the Mr. Dlamini has come to my office just to get some help using my Wi-Fi. Thank you.
All right, thank you.
Advice accepted.
Thank you. Colleagues, this brings us to item 8. Madam Kapika, anything, can we take that as read, but maybe you can highlight anything new that you may want to add?
Yes, Chair, I will do that on her behalf. She's attending to other NERSA business.
All right, thank you. Thank you, Mr. Ntanzi. Please proceed, sir.
Yeah, just to take as read as you indicated, Chair, but she requested that I highlight the following, that we have the following appointments at board level: Mr. Tembani Pugula as the chairperson, Ms. Zandile Mpungos as the deputy chair, Ms. Precious Sibia, part-time regulator member, Ms. Tembega Simane, part-time regulator member, and Mr. Fungai Sibanda, part-time regulator member. Lastly, Chair, to wish those colleagues that will be running Comrades Marathon this Saturday well, and that they will fairly represent NERSA. Thank you.
Thank you. And Mr. Mkiza, I always forget to then close the meeting before this one. Apologies on that. Well, we are right at the end. And yeah, I would like to congratulate especially our current member, Madam Pungos, for being confirmed as the deputy chairperson, and to welcome back Mr. Pugula, and also all of the other new members, and to welcome back also Mr. Sibanda. He's been a valuable member of this particular committee. So thank you all. And those that are running comrades, please don't drink Devon water. From what we understand from